Now, some now feel able to my church terms in the draw song. A meeting no air no the attorney, make a celebrity, me bonnet tougher, send a bear, or better see. So it was 7th December, Ghana Yatwaba. Now Yatwa baby, you know, not just a parliamentary side, no NDC MPs Nibi. I Winnie. In fact, it's on video, said AEC returning officers on one castle may declare say those constituencies in question no or declare almost or mono winning. But after that, no NPP and MPs literally will say Omontiase and Rintino Omodia or Mobile Court. Now, before that, electoral commission about Bontibich will say I Omoankasano returning officers need be hopper now or declare resource no Emma and this now. They were under duress. I had to say in Shebi na dey be ho would make it that declaration no enu nti no I omobasa Re-Collation for. Now enu na ebusia 16th December NDC omoko high court say court and stop it EC say I oni ho kwan so be Re-Collation na was say declaration for because omodi nkan aye saa de no dada. Enu na fast forward NPP MPs no almost 17th December omoko high court a omo chiremu say eja high court judge yesrawa Electoral Commission or you may be a yenno and yardry. And you know, Yabasra was said, what high court judge no use power. Not share easy. In Bremoni will be a friend of Mandemus. And one and said, court no and share easy said, Uncle collation. Now if you only declare winner, I hear you said. So we declare there, here NPP MPs now. Beginning of much say you lose no here and you be winning. So it was a high court judge, no, yes, or no, do the assam. Now it's on record said. NDC or more mudi kind of some echo court 16th no high court judge when this asam but OD NPP or more court 17th no the same high court in front of the same judge. So fast forward ebusuya easy or more re-declaration no for now ahana someone no and I'm lawyer edugita maklu or the assembly kopie Supreme Court said I just Supreme Court or more share no more BB and some no Supreme Court no or more ye no.
My lords, our ground for this application is that the orders made by the High Court were made in breach of the applicant's rights to be heard. My lord, the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55. My lord, should not, with the greatest respect, be endorsed because the precedent will be dangerous as far as the rule of law is concerned.
The High Court judge, you know, or your bias because Omo NDC for crown no omo kire say papa won't me say it is unko re-declaration because ya kire video and no kire say declaration no akọ in favor of NDC. But ebusia edu yitama kro kan ansam na say judge no went to omo asam no Supreme Court judges no omo ankasa no they were shocked.
The applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My lord, they were before him. Yes. I stood up. Yes, my lord. That's the unique thing. I stood up and brought to his attention that, my lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December, this mandamus application was filed on the 17th. But my lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same. Okay. Was it pending in that court or it was right before him?
My lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my lord's attention. But my lord, these are declarations with video evidence. So consider my application first. He ignored it. At the time my lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it. And started giving his ruling. My Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the mandamus. He knew that would definitely affect their rights. So, my Lord, it's on this basis that we invite this honorable court to pass the orders of the High Court General Jurisdiction 13.
So, and the Electoral Commission, lawyer, no, you're sorry, yes, objection, my Lord. Kind and the way Italian say, you know, say yes, and then the rebels who got her. Oh, Chamu say, or one some can, now interesting. Or one can some now, can you do baby? Judge in a piano, or friends of a part. Can you say I gave up? Well, now the underlying word is mania.
So far, in the submissions, I have not heard any submissions to say that the judge erred and that error is on the face of this record and is jurisdictional and therefore the Surera should lie. Respectfully submitted. Thank you.
Oh, Counsel.
Right.
But you argued Hawa Yakubu in your... You argued Hawa Yakubu.
Yes, my Lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My Lord, the order had had an injunction placed. But in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my Lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my Lord. And then also, one last thing, now that you have brought it up, my Lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my Lord will look at it as an application. My Lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you.
Counsel, take your time. I like the word mania.
NPP, or more lawyer, Mr. Gary Nimakon, or also the sorry ya. Or can send be say, oh, what shall Eastern and Hawaii now? That's all, they are not quite sure. No. In fact,
my Lord, the High Court only made an order directed at the public body to perform public function, to simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, who the court made for the EC, the first to go and collect and declare who has won or who has lost, my Lord, it's a public function. Public function. How does that order to go and collect and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
My Lord, Exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
The collation sheet.
Which is a parliamentary election results summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My lords, with all respect.
Because they have a right, even at the administrative level, to object.
Yes, my lords, under the CI 127.
Yes.
If a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lords, with all respect to you, to the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted, and you want to challenge the result by way of an election petition. Petition. My lords, with respect, at the time when the court was making an order for Madam's application, this exercise I don't be effective. But now, personally,
I'm just trying to say that what the applicants are saying is that they stood to be affected, and you are saying that they would not be affected. Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Minubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you. But it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lords, I mean, this particular exhibit D6, 7, 8, and 9, its content therein were not factored in at the time when the court making an order that proceed to go and do collation and declaration.
Okay, agreed.
In any event, my lords, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed.
Oh,
so close.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantively.
My lords,
yeah.
My lords, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that would be, the consequences are clear in the authorities.
I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that another High Court judge exercise a discretion. If the applicants are agreed about the discretion so assigned by any High Court judge, their remedy lies in an appeal and not, my lords, we submit accordingly.
Thank you.
My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
Court judges never so much funny after you know, after the judgment. Now, and someone more can now, it was Hannah someone.
Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of the Sawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaigwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Ahafwano North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statement of case in answer to the respective applications for mandamus which have not been quashed. Now those which have been quashed, sorry, those which have been quashed, yes. As interested parties, the time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful.
So judgment when the Supreme Court or Modi Tuga. Now momentum abo, let me break it down. Nia Supreme Court omo kani nyina ne se omo etie afane afa obia aka ne sem na omo so de omo judgment a omo di to dwa no. One, eno ne se some of the constituencies as esia no omo twe ho man so no mako 6. Now, out of 6 no 2 in Sewom Adwojiri ene afi ahafo ano north de omo chiremu a nea high court judge no kan ye no ana say easy Re-Collation ana say declaration omo ye no eno de eno ano no inteno those 2 seats no NPP omo ewini fencham number mo no 4 constituencies Techiman South, Tama Central, Okaikwe Central, any Ablikuma North de Re-Collation a ECA no foforo no oma cancel. Previously, old one no mo ye na Baba Sadiq be bright any Techiman South MP no ai omo de omo wini ye no eno ene sesi aye kasa na de omo no mo ye MP elect. Number mo no say NDC omo aka say high court judge no wentie omo asem a wasan aye bias no enu nti no omo Supreme Court omo chiremu a 31st Tuesday we no asam no different high court judge ebetna that asam no so nene de omo ahwe no mu de ye atu ye nti Supreme Court o kan nyina na say in prepare aye kese de dada no NDC MPs no omo wini those 4 constituencies na mebobo so no omo no mo ye MP elect until further notice ebusia different high court judge obetna asam no so obetie NDC for nkomo wetie EC na wetie NPP for ehun fata so obama EC no mandamus ne say onko ye Re-Collation for anasama no nkoye inti as it stands now no ebusia Baba Sadiq be bright omo na ebusia those 4 constituencies no omo ye MP elect inti say ene kosi ye Supreme Court just say NDC for no omo jubilate and